All right, good morning and welcome to our last healthcare helpings of 2017. I know we have a fairly intimate group, so I apologize for the microphones, but this is being recorded in order for the dialogue to go through. We got to use the mics to get it recorded properly, and it will be posted on our website later, so you can go back and view this or share it with your colleagues. Let me get this going here. There we go. Although this is our last healthcare helpings of 2017, we got a couple coming up in the next few months in 2018. The first being What the H, which will focus on HIPAA, high tech, and high trust. Now be led by my partner Gina Pruitt, who leads our IT assurance team here at Kraft. And then at the end of March, we'll be doing practice management best practices, which will be led by my partner Lucy Carter, that leads our healthcare practice at the CPA firm. But today we're going to talk about compliance. And first of all, I'd like to introduce the panel. J.D. Thomas is a partner with Waller, Lance & Dorchin Davis. And previously, he was Assistant U.S. Attorney with the U.S. Attorney's Office. So he has kind of a perspective from both sides, from the government side as well as on the defense side. Next, we have Brittany McClafferty, who's on the right. You can see Brittany and Stacy compete to see who have the most acronyms behind their name there, the most initials. But Brittany is a coding compliance consultant here at Kraft. She focuses mainly on behavioral health. She does have a clinical background in the behavioral health space, so she primarily works with on the psychiatric side, and that's no reflection on her psychiatric well-being. And she does work with a number of behavioral companies, including two of the largest behavioral companies in the country. And then last but not least, on the left, Stacy Sternberg is also a coding compliance consultant with Kraft. She has a strong background in E&M coding and auditing, as well as a billing function. In fact, prior to coming to Kraft, she owned a billing company for a number of years and then worked for a few other providers, including HCA. So let's just talk briefly about compliance, and then we'll turn it over to the panelists. But just under 30% of all healthcare organizations report that they have a strong compliance plan in place and assess their staff on a regular basis. That leaves over 70% of these organizations that basically have nothing in place and they are at high risk. So we're going to start out today. Brittany is going to talk about compliance in general. And then Stacy's going to talk about the OIG and the OIG Work Plan. And then JD, from an attorney's perspective, is going to look at the government and federal health care fraud and abuse and the repercussions from that. So I'll go ahead and turn it over to Brittany.
Thanks, Scott. You guys hear me okay? All right. Before I get started, I just want to point the book out to you and just kind of tell you what all we have in here. First, obviously, are the slides. After that, we have OIG enforcement case examples. All these case examples that we've included in here are from Tennessee. And we included these to just let you know that all the issues that we're talking about today are real and local, and nobody is safe, and it's not some abstract concept out there. After that, we have a bunch of resources listed for you, sources that we use to build our presentation today. Following that, we have lots of compliance terms, abbreviations, and acronyms. We use lots of acronyms and abbreviations throughout the presentation, so if there's any that you're not familiar with, just turn to that index in the back, and they're all in alphabetical order for you. And in the back are our bios. All right, so getting started with compliance. The main point I have is that it covers a wide range of actions: billing for unnecessary service items, kickbacks, upcoding, performing appropriate background checks, and even something as minor as what to do in case of a fire. And no matter how common sense everything may seem, there should be policies and procedure in place for nearly every single thing that happens in your organization. From when the patient walks into the door, how they're treated and greeted, and their personal or private information is handled by the front desk, how the physician documents every visit, how the bill gets sent out, and compliance should be considered in every single step. And this affects every single organization, no matter the size. All right. So when working with clients, a common complaint that I hear from providers is that they don't have enough time for all the intricacies of compliance. We're healthcare providers, and we're here to provide quality healthcare for these patients. We don't have time to be filling out all this paperwork and keeping up with all the documentation. We're here to be doctors, and we are doctors, and we're not in charge of compliance. But patient quality of care should and always be the first priority, but the quality of care is not mutually exclusive with compliance. Patient care can be enhanced by compliance plans, like the increased accuracy of documentation that results from a compliance plan enhances patient care. A well-designed compliance plan can speed and optimize proper payments of claims, minimize billing mistakes, reduce chances of a government audit, avoid conflict with self-referral and anti-kickback statutes, and then JD is going to go a little bit further into that for you guys later. Development and continuous effort put into a compliance plan shows a good faith effort in case you ever are audited and fined or mistaken by the government. So when you're putting forth all that effort, it reflects very well upon you when you're going through that process. And then having a plan in place also sends employees the message that while mistakes can, will, and do occur, employees have a duty to come forward and report any sort of incorrect or fraudulent behavior so that it can be corrected. Now, the goal of the plan is to attain balance between the regularity and safety of the organization is maintained, and any dangerous or vulnerable behaviors are avoided. The plans do not only need to be in place, but also need to be kept current. You need to not set it and forget it. Lots of times when we go into one of our clients' offices, you say, what's your compliance plan, and what do you have? And they're like, oh, it's in a binder over here in this back office, and they pull it off some dusty shelf. This is something that needs to be continuously reviewed, updated, and discussed with your employees. It just shouldn't be on some back shelf that's forgotten about. This really is very important. Policies and procedures should be reviewed at least yearly by someone knowledgeable in order to determine the compliance plan represents the four whats: what needs to be done, what the organization wants to do, what the organization actually does, and what the organization is required to do or should do. All right. So at the most basic level, compliance plans are internal policies, procedures, and standards of conduct that your organization establishes to just adhere to the law. But if you want to be best practice and be really effective with your compliance program, you will be enhancing your operations, improving your quality of care, reducing your overall costs. And as long as you're being proactive and identify problems before they come up early, then you won't have any issues in the future, or less issues in the future. The OIG does not provide sample compliance plans for you guys, but they do provide lots of compliance program guidance, known as CPGs, that provide principles to follow when coming up with a compliance program. So what we have here are the 7 core elements of a compliance program. The first of which is that the organization should have written policies and procedures. They should detail standards of conduct that are shared with everyone, again, continuously updated, and they should be proactive, job-specific, and reviewed frequently. You should designate a compliance professional, even in a small organization. Somebody in particular needs to be in charge of keeping up with all these compliance responsibilities. This should be treated as a serious job, not somebody's additional task that they're going to be doing on top of a 40-plus hour job already. This is a huge responsibility, and it needs to be treated with respect. They should be keeping up with the responsibilities of all the guidelines and regulations, overseeing and monitoring the implementation of the program, and establish methods such as auditing to improve efficiency, quality of service, and assessing their vulnerability to fraud and abuse. They should be periodically revising plans when they are shown to not be working very well, coordinate trainings, continuously checking the OIG exclusions list, and investigate any reports of unethical business practice that they come across. Then organizations should be providing effective training. They should educate employees and make sure that they all understand the policies and procedures in place. I like to compare training to exercise. You can't just exercise once a year and expect results. So you can't just have one yearly compliance training and then expect everybody to be in shape with their compliance duties. It needs to be done. Take the initiative to train often and not only when problems arise or it's absolutely required to. You need to determine who needs training, and if you can, cater those trainings to those individuals. If you know them well enough, what kind of learning style do these people enjoy the best or work the best with? And if you can, this stuff isn't the most exciting, but if you can make it fun and creative, that's always helpful. I've had clients who've even done like compliance Jeopardy, so they break up into teams and then it's more competitive and fun and you're learning things as you go along. So it doesn't always have to be a cut and dry reading off slides type of situation. And the next core component is effective communication. You should foster an easy and open line of communication between the employees and the compliance professionals, and develop an effective way to inform employees of the changing guidelines. A bulletin in the back room is probably not going to get read, so we need to come up with more creative and effective ways of sharing new guidelines and requirements. We also should supply convenient and easy ways to report failures to comply that do not have any sort of backlash against the employee. So there's hotlines, comment boxes, open door policies. The compliance professional should be visible and easily approachable. So studies have shown that when available, utilization of an anonymous online reporting system is the most common and easily used for employees. So if that's something that you can set up in your facility, I highly recommend that. The next component is internal monitoring. This should be used to review the effectiveness of your compliance program through auditing and monitoring. You should perform ongoing evaluations, and this ensures that your practice standards are up to par, everything is accurate, and everything is flowing smoothly in your organization. Audits are an excellent way to identify problems and risk, and there's two types of audits that you typically can do. The standards and procedures audits, where you check policies, procedures, make sure everything's current, and then a claims submissions audit. That's where you review bills and medical records for compliance, coding, billing, and documentation requirements. You can do that concurrently or retrospectively. You can do it in-house or out of house. Don't wait until a team member tells you that you aren't coding correctly, or a payer comes back and tells you they're not coding correctly. It's easier to stay on top of these things than get a letter from Medicare saying, oh, we're going to come audit you and you owe us $1 million, because it compounds, and we'll go a little bit more into that with Stacy about how one false claim can just snowball into this enormous payment from your facility.
It also helps you, it also helps you avoid having a federal prosecutor send you a subpoena.
As friendly as he is.
Sometimes more problematic than Medicare, yeah.
Right. Another important component is to enforce your standards. Don't just stop at educating and talking about it. You need to make sure you take action when misconduct occurs. Make certain that everybody is aware that there are consequences and that the consequences are real. We don't need slaps on the wrist. We need to see that this happens, this is real, and bad things can happen when you don't comply with the regulations. Also, promptly respond to all issues. Look into everything immediately. Don't get a report, set it on your desk, and think, oh, I'll worry about that in a little bit. No, treat it as important as it truly is, and address this with employees in any other department that is relevant in the situation. You need to create a system for how your organization responds and reports to all these potential problems, and develop a way to track issues and your responses to previous occurrences, so that way if something similar happens in the future, you can reference back to it. Okay. So for our compliance steps, you should implement a process to verify all clinical licenses online, and do not accept paper copies. Implement a process to conduct the OIG exclusion checks upon hire and regularly after. The OIG recommends checking the OIG exclusion list monthly. So lots of people are surprised that it's that often, but you never know when people's names can pop up on there. And then also the OIG interviews individuals when they come off of the exclusion list to see where they've been working in the time where they excluded. So if you're named and you weren't diligent about checking the OIG exclusion list, then you're going to be the one that's in trouble. So don't let that happen to you. Make compliance plans and compliance part of people's job descriptions. State in their job description that it includes compliance duties, who should they report to regarding the compliance issues, and state in their job description that their employment is contingent on compliance. I've had one client who had one very stubborn doctor that didn't want to do the extra work that was required by the compliance guidelines, and he says, it says nowhere in my contract I have to keep up with that stuff. So here's a nice little thing that you can stick in their job description where it is. And then make sure to check the OIG website, use the resources available to you. They have a Compliance 101 site, and it has lots of handouts, presentations, guides, tips, and videos. So it's a really great resource that you can use for your providers.
How many folks here are checking that OIG exclusion list on a regular basis?
All right, and then here are some medical record documentation tips. I won't read it to you guys, but the most important thing is to be accurate, specific, and thorough, and most importantly, be aware of the OIG Work Plan. Stacey's going to go a little bit more into that, but just be aware of what the government's taking a look at so that you can be sure to be thorough in those areas.
Please be thorough, because when you're investigated by the government, the documentation is the only thing that you have. And we deal with that a lot. I was talking with somebody about it yesterday. When, you know, the government will come, Medicare audits, they look at the documentation, they seek an overpayment. That's one thing. The federal government will come along, DOJ will look at the documentation, say the documentation was deficient. You knew it was deficient. It's a false claim, and Stacey's going to talk about that, how expensive that can be. But that's all you have. I mean, that's, you know, 3 years later, doctor's gone, patients maybe have passed away. All you have is the documentation, and it is so critically important, and we see that all the time on the back end. And I think we deal with a lot of clients who wish that they had much more comprehensive documentation after the fact.
Any questions at this time before we move on?
On the OIG exclusion list, what's on the list? Is it providers, practices?
It's provider name.
Wouldn't we
And individuals.
on the exclusion list?
Sorry, what was that?
Wouldn't we have known if the doctors were going to be placed on the exclusion list? How do they get on the exclusion list?
It could have been from a previous employer. Could have worked at a hospital, got excluded at some point several years earlier, and then they went to work for your practice.
And it includes everybody. So it includes, there's a lot of there's probably more like LPNs and just random employees than there are doctors on the exclusion list. And so anybody that you employ in any function that touches patient care that's on the list is problematic.
And there's real examples of where, let's say you hire an employee today, maybe 6 months ago, a case came up where they're being investigated, but it hasn't come to completion. They've not been, so they're already working for you before it comes down and their sentence says, okay, you're excluded, you can't participate. So you'd have no way of knowing that unless you continually check that list.
They're probably not going to volunteer.
Yeah, Lucy has a great example of one of those. OIG.hhs.gov. Yes.
Yeah. Yep. Just type in OIG exclusion list in Google, and you'll come to it.
Yeah, there's third parties. Once a month is a lot, but again, that is the recommendation.
Okay, mine's the really boring part. I get to tell you about the OIG. The OIG was formed in 1976, and it's the independent oversight agency for the U.S. Department of Health and Human Services. Their basic mission is they are there to protect the integrity of federal health care programs like Medicare and Medicaid, as well as the health and welfare of program beneficiaries. Before I talk about the core publications, does anybody have a guess of how much fraud, abuse, and waste costs the taxpayers each year? What you got? $30 billion to $100 billion a year. They say, while experts estimate, and they don't have an exact number, they say anywhere from 3 to 10% of everything billed is fraudulent, waste, or abuse. Sorry. And then the government spends $1 trillion on Medicare and Medicaid programs every year. Those stats just blew me away when I was looking up this. I mean, that's a lot. At the beginning of each fiscal year, the OIG identifies weaknesses in DHS programs and actions. And based on that information, they work to improve the efficiency and effectiveness. And it's a year-long process. The OIG has 3 core publications, and I'm going to talk mostly about 2 of them, the Work Plan and the semi-annual report to Congress, the Compendium of Unimplemented Recommendations. There's your description.
They have a lot of unimplemented recommendations.
Yeah, I read that, and it was just okay. Semi-annually, I'm going to save the Work Plan for last, but the report to Congress, they have to report for every preceding 6-month period, and based on that information, that's how they decide what goes on the work plan. They say, and that's how they decide how much money that Congress, it affects the budgets and things that Congress says, okay, this is how much money we're going to spend. In 2017 already, the first half, the OIG reported expected investigative recoveries of over $2.4 billion. So far this year, and this was, like I said, the first 6 months, the OIG reported 468 criminal cases against individuals or entities that engaged in crimes against HSS programs, 461 civil actions, and 1,422 exclusions of individuals and entities from participating in federal health care programs. And I think, like Brittany said, when we put this book together, I wanted to show that all those cases, they're from Tennessee. It's not, New York or Florida or Miami you hear about somewhere else. They're here. They're everywhere. So it's not an option anymore. I'm going to tell my age, but when I started in healthcare years ago when there was a UB 82, policies and procedures, they were there, but it was not something that you regularly refer to. Now it's not an option. It's just the OIG, with everything they do, and they do it for the benefit of protecting the programs and the beneficiaries of Medicare and Medicaid. So the work plan. The work plan has, how many of you have ever gone on the OIG website and looked at the work plan? It's broken down by section, and it'll tell you, like, it has a section for skilled nursing and tongue-tied. It has a section for, like, skilled nursing, particular providers, Medicare Part D, all those things. One of the things that I noticed, and I put a couple on the slides, was about the cloning of the EHRs and the incentive payments. They are looking, one of the actionable items is that security of electronic certified EHR technology under meaningful use. When meaningful use came out, everybody adopted a software system and they said, okay, I'm going to attest to meaningful use, without really knowing what that meant. So there are a lot of resources available, and that's the things that Medicare is looking at. And this work plan, it's published annually, and the work plan lists various projects that are going to be addressed by the Office of Audit Services, Office of Evaluation and Inspections, Investigations, and Council of the Inspector General. And this is something new. You've all heard of ZPIC audits, but beginning in 2017, they sort of combined several of the processes together, and now they're calling them UPICs. So to better coordinate audits, investigations, and data analysis, and to lower the burden on providers, Unified Program Integrity Contractors are what they're having now. Instead of ZPICs, PSC, and Medicare, Medicaid, date match programs, it all falls under that UPICs. And again, I mentioned this being on some of the areas of focus is the Medicare incentive plans for adopting EHR medical records. We recently had a client that attested to meaningful use and then found out that there were some issues on the back end, and we came in and we had to say, okay, did you attest correctly? We had to look at several thousand accounts to say, okay, was this reported correctly? Because it could have amounted to a lot of money. So that's something to be mindful of. Just because it happened, you did it 2 years ago, that doesn't mean it's over and done. The OIG can come in and will come in if they have a report or a suspicion that something's not right. Mm-hmm.
For the OIG, sort of depends on what theory they have. I mean, there's a statute of limitations on False Claims Act actions, and then there's a reopening period for claims. So it sort of depends on how they're, who is looking at your claims and how they're looking at them, right? I think typically the administrative period is going to be narrower than than if they're looking at it from the point of view of a False Claims Act action. So the short answer is yes, but the long answer is it depends on, depends on how you're being investigated.
Roughly what is that range? How far back?
Under a False Claims Act action, up to 10 years back. So, if it's real egregious and it's fraud, the government can look back 10 years, so they can go back to 2007.
One of the things I want to make sure everybody understands is when you talk about why am I getting audited by the OIG, what do they look at? Sometimes it's statutory and regulatory requirements, your susceptibility to fraud, waste, and abuse, the dollar magnitude that they think exists, a result of a prior audit. Let's say, again, we had a client who had been audited by Medicare 7 years ago, came back in recently, got a second audit, and there were no improvements. So, those are the things that they look at. Hotline complaints. That's one of the things I really wanted to bring to everybody's attention, especially practice managers and compliance. And we all get busy and we all have our stuff. But when an employee comes to you, they are your best source of information. They are at ground zero. They're the ones actually doing the work. So if they come to you and they tell you that something's awry, look into it. It may or may not be correct, but if it is, you're being proactive. And if it's not, you can show that you've investigated it if something comes up later. But don't just dismiss it. All too often, that's what happens, and employees get frustrated. And the OIG has a hotline, and when they call in that hotline, they can do tips anonymously. And I put in here, everybody is familiar with eClinicalWorks. I know that's a big software here in Nashville. They just had that lawsuit where they settled for, I think it was $155 million. The person the whistleblower, the former eClinicalWorks employee that worked for them, they stand to get $30 million for turning them in. There was a Murfreesboro podiatrist. He just got a $250,000 fine. He got 10 years in jail. And guess what? His employees testified against him. So I say all this to say, just listen, be open-minded, and listen to what they have to say, and just do the research on the front end. It's like Brittany said, compliance is so important, and it has to be treated with the respect it deserves. So when an employee says, hey, because again, they are the front lines.
Yeah, and I think Stacy makes an excellent point. The other thing to keep in mind is not only is there an OIG hotline, but there's an incentive, and you alluded to it with the payment to the whistleblower in the eClinical Works case. There's an incentive built into the False Claims Act for people to come forward and quote unquote blow the whistle and serve as relators. Under the Act, they're entitled to a percentage of whatever the United States recovers, and that percentage varies from 15 to 25%. That's a lot of money, so people do that. They're motivated by money, and there are relators counsel out there who have, they run like plaintiffs' shops. They have intake. They have paralegals. You call their number, and paralegal picks up and talks to them about the case, and they decide whether or not it's a case that they want to bring. And they have feeder networks, very sophisticated operations. The big ones, they have, some of the bigger ones have people on staff to optimize, whose job is to optimize their Google search results. So they're out there. They're out there looking for your employees who want to blow the whistle. How do those people end up there? They end up there because they're ignored. I mean, there's a lot of misanthropes. There's a lot of serial relators who just want to complain. But there's a lot of people that just got ignored. And I when I was with the government, you have to interview every relator, right? I've talked to a lot of whistleblowers, and I would ask every single one of them, what did you do to tell the company about this? And I had maybe one or two that said, nothing. I just filed a lawsuit. But by and large, most of them would say, well, I complained and I said this was wrong. And I said, well, what happened? And I was ignored. And in a lot of cases, they were fired. And then they felt like they had the one opportunity available to them was the False Claims Act. So you can't ignore people who come forward, even if they're wrong. You certainly can't fire them. But even if they're wrong, you can't ignore them. You have to take them seriously. You have to listen to their complaints, and then you have to, if it's credible, you have to conduct an investigation under your compliance plan. And I think you have to circle back around with them. And you don't necessarily have to tell them, hey, we fired Dr. Jones, but you do need to say, we've conducted an investigation, we've taken appropriate action. Thank you for coming forward. That's how this is supposed to work. Appreciate it. Because if you don't and they don't know, then they may go do something. And the reason that you have to take all of those complaints seriously, I think, in today's day and age, is because the False Claims Act, and we'll talk about this, but I'll just say this now, there's a statutory requirement that the government investigate allegations that are brought forward by a relator. So when you have a False Claims Act action, a Qui Tam, filed against you, it is filed under seal, and the government has 60 days, which can be extended sometimes to years, to investigate you while that complaint remains under seal and hidden from public view. So you don't know about it, nobody knows about it, but the government's investigating you, and they're investigating you with information provided by somebody who's inside your operation. The government is required to investigate you. It is required to conduct an investigation of the allegations in the Qui Tam. And I can tell you sometimes those investigations, at least when I was doing it, were like, 2 weeks or, 15 minutes of like, this is clearly not, there's no credible allegation here, so we're going to take a pass. Other times they're longer, but you have a federal prosecutor who is statutorily obligated to be investigating you. It's never something that you want in any context. So that's why you have to take those people seriously. If there's one thing that you sort of take away from today.
Well, and the other thing is employees need to feel like they've been heard, because once they feel like you hear them, they feel like, okay, it sort of gives the sense of they care, they want to be compliant, they want to do the right thing. So that is a good way to, a good idea to always circle back. I'm going to go over 3 categories of resources and guidance are available, and then I'm going to turn it over to JD and let him talk about all the laws and everything else. I think he's a great resource. But Brittany alluded to it. The OIG has three main categories of guidance and resources available. The first one is compliance program guidelines that they call CPGs, and they're the most comprehensive in their collection of information, and they're organized by industry sectors such as, again, skilled nursing, hospitals, particular providers, specialties, that kind of thing. To date, there's been 11 issued with 2 supplementals. Now, if you look at the dates on them, some of them are really old, but they're still applicable. They're still, if you were to call the OIG, they would still refer you to those same things, and they're on their website. So don't just dismiss it because it has a 2007 date. They still feel like that is applicable. And the CPGs, what they do is they refer to principles and suggested practices that, not only help build a good compliance plan, they give examples of risk areas, things not to do. The second one they have is specific special fraud alerts and special advisory bulletins and other guidance. These are issued when they identify a trend. They say, okay, bundling or unbundling or certain injections, things like that. They'll issue a special bulletin or an advisory that says, hey, here's what we're seeing, want you to be aware of it, and this is not okay. And the third thing is advisory opinions. If they won't research hypotheticals, they won't give you an advisory opinion on a hypothetical, but let's say you're going to go into business. One of the examples they used was a physical therapy group going to go into business with a skilled nursing, and they had questions about what was okay as far as legally, things like that. If they've looked at the advisory opinions available and they're still not sure what's okay, there are steps they can take and ask for an advisory opinion from the OIG, and that is legal and binding, and it protects them from prosecution, but it protects them and only them. So just because you read it, it doesn't protect you. It's just the person that filed it. So, and the last thing, that OIG website has an advanced search feature that if you just put in any topic, it will pull up. It's a really nice feature. It will pull up anything they've ever printed or anything they've ever said related to that topic. So I would suggest everybody make themselves aware of that website, know how to use it, and you can also sign up for email updates and things like that, where I found this amusing. They said you could follow them on Twitter. Okay, I don't Twitter to begin with, but if I did, it wouldn't be to follow the OIG. I'm sorry, that was a little much. All right, with that said, I'm going to turn it over to JD and let him. Thanks. Take it away.
Well, thank you. Thank you both. Thank you for having me today. It's a real pleasure to be here talking with you all. I was going to talk about some of the laws that sort of surround fraud and abuse, and we could be here all day talking about that, and nobody wants to do that. So I'm going to try to hit the high points. I think what's important to recognize too is the OIG has a very important role in all of this, but the OIG never shows up alone. They always show up with the Department of Justice, because outside of something called the Civil Monetary Penalties Law, the OIG does not have prosecutorial authority to enforce laws. It can enforce its regulations administratively, but it doesn't have prosecutorial authority. So it always shows up with the Department of Justice, and that means a federal prosecutor. That means potentially FBI agents. That means very serious problems for any organization. So some of the laws that apply run the gamut, from criminal health care laws, the False Claims Act, we're going to talk about that, Anti-Kickback Statute, a whole panoply there, exclusion authority, civil monetary penalty law. So let's go through some of them real quick. Anti-Kickback Statute, you all should know what this is. It prohibits the payment of any remuneration to induce referrals. Is essentially what it says, and that can be any payment. We spend a lot of time analyzing relationships, arrangements for kickback violations, and kickbacks can be very broad. I have heard articulated a theory that not firing somebody was essentially a kickback, that not firing a doctor who was underperforming according to a company was a kickback. So it can be very, very broad, and I think you have to come at it like that. Everybody thinks, cash across the table, and one of the cases that Stacy, the press releases that Stacy has in this book, or we have in this book, includes a case that had cash across the table. So that's a kickback, right? But it can be very broad, and you want to think about it in that context. The other important thing about the Anti-Kickback Statute is that it is criminal in nature. So you can go to jail for violating it. It's not just civil. You don't just have to pay back money, but you can actually end up in jail. And a lot of people do. So there you see some of the penalties. Obviously, 5 years imprisonment, $25,000 fine. It's also covered by the CMP statute, and it's going to get you excluded as well. The next law that comes up quite a bit in our world is the Stark Law, named after a congressman or senator from Pennsylvania, Pete Stark, who has since disclaimed it. Stark is very, very complicated, but in its essence, it essentially prevents a physician from making a referral to an entity that provides designated health services which they have a relationship with, financial relationship with. There are a number of situations that are specifically excluded from Stark. So it gets very complicated how to analyze it. It's also, there's no intent to violate Stark. So you can have what are known as technical violations of Stark, so unsigned leases, and those sorts of things, which carry the same penalties until very recently were treated often very the same way by CMS, which is charged with enforcing Stark. So it has been thought of as a very onerous law. I think, a little inside baseball, I think the government really likes the hammer that Stark brings. They like some of the policy issues that it drives, but they recognize that applied in its purest form is incredibly onerous to companies. So there's an internal struggle within the DOJ, CMS, those that interpret it to handle it in a way and use it in a way that's not going to get it taken away from them by Congress, and do things that are just sort of wholly stupid enforcement-wise, that has Congress then say, well, why did you do this stupid thing? You don't need this law anymore. So that's kind of Stark in a nutshell. Here's a little comparison of Stark and Anti-Kickback Statute. They're very similar, but obviously the penalties are different, and the exceptions are also important. With Kickback Statute, it's voluntary safe harbors. So there's guidance as to whether you fit into a safe harbor or not. Under Stark, it's mandatory exemptions. Certain things are exempted, other things are not. And also, the application, Kickback Statute applies to all federal health care programs. So that should be read as all Medicare, Medicaid, that's what we think of, but the federal government pays for a lot of other health care. And there have been cases where kickbacks have been alleged in non-Medicare, Medicaid context, so federal, FEP Blue, those sorts of things. Stark definitely applies to Medicare, maybe applies to Medicaid, unclear. So those are yes. Uh-huh. No. It applies to all. It applies to all entities that are providing designated health services. So for-profit, not-for-profit.
So is the big difference between the two, the anti-kickback is really kind of physician to physician or practice to practice, and the Stark Law is physician to entity?
The Stark Law is physician or certain people associated with physician's immediate family and entity. An entity providing designated health services.
That could be another physician.
It could be it's typically going to be a hospital, right?
Well, that's what I've always thought of, but that's not the way you.
It's not. You can't say it's just a hospital, but I mean you have to get into what you have to get into the case specific issue of who's providing what and what the financial arrangement is. So it's hard to say. Do you want to?
There's a group practice exception that would apply to most physicians. But the bottom line is that you still cannot, a physician cannot be compensated for the volume or value of the referrals that they make for designated health services. And thank goodness designated health services are not listed up. So there's no question about what they are. But in your compensation formula, you can, if Dr. A orders a X-ray, if it's an equity kill formula, that X-ray compensation should be directly for her.
Yeah, no, that's. I mean, it is very complicated, and
I'm trying to look for like the easy, like if my doctor asked me and said, well, what is the difference between the two? My interpretation is really maybe I am wrong because it sounds like you're saying that it's not an entity can be more than just a research center or a hospital or a public.
it's an entity that provides designated health services. So yes, it can be broader. And then something you mentioned about kickback too, it is broader than doctor to doctor. I mean, it is the payment to anybody who can influence referrals. So it can be, if you're an administrator in a practice and somebody's giving you money or incentives and there are referrals flowing to whoever controls the entity that's giving you that money, then that's a problem, and that could be kickback. So the kickback is much broader, but it can be anybody who has the power to influence referrals. False Claims Act is sort of the government's primary tool in enforcing fraud statutes, including the Anti-Kickback Statute and the Stark Law. We talked a little bit about the False Claims Act and some of the provisions in it. It is a very, very powerful tool and a very broad tool utilized by the government. It makes it unlawful to knowingly present cause to be presented a false or fraudulent claim for payment or approval, knowingly make, use, or cause to be made or used record or a false statement, and then knowingly make, use, cause to be made or used a false record or statement material to an obligation to pay or transmit money to the government. That's sometimes called the reverse false claim provision of the Act. Knowingly conceal or knowingly improperly avoid or decrease an obligation to pay or transmit money or property to the government is sometimes called the reverse false claims provision of the Act. Suffice to say, taken together, that covers pretty much any claim that's provided to the government. A couple of really important parts about the False Claims Act that you need to take away without getting into the nuances of how it is enforced and interpreted. Number one, it requires intent. So it says knowing or knowingly. Under the Act, that can also include reckless disregard. So you can intend to, I wrote this false claims out, I sent it to the government, please pay me, I get it back, I have my ill-gotten gains, I know about it, right? But you can also act recklessly. Dr. Jones can give you something, and Dr. Jones wasn't there the day that the claim says he provided services, and you knew he wasn't there because you were fishing with him, and you signed the claim and you send it in, and that would be reckless, right? but intent is important. And that's a very important thing to keep in mind, because it is not intended to cover honest mistake. You know, if you have just made a mistake in how you're coding something, it should not be enforced under the False Claims Act. It should not be subject to, we'll talk about this in a second, treble damages, penalties. It also requires a claim. So it also requires some form of claim to the government. Penalties. It's the False Claims Act is a punitive statute, so it provides for trebling of damages. So we have a little math lesson here, and I'll let you read that as I explain a little bit about the multiplier. When you get into these cases and when you talk to the government talks in multipliers. So in order to settle a case, if the government thinks it has real allegations, they're going to be looking for a multiple of the government's actual damages. So that would typically mean that the claims that were submitted. The government applies different theories of damages depending on the underlying conduct. If it's a kickback case, the government, or a Stark case, the government takes what's called a tainted claims theory. And this is where it gets very onerous, and this is where you see settlements like the Toomey settlement. I don't know how many of you are familiar with that, but Toomey is a hospital in South Carolina, I think. One of the Carolinas, and had fought a Stark allegations against the government, lost at trial, and ended up having I think the trial verdict was $300 and some odd million, and eventually settled for somewhere between 50 and 120 million, I think. So it's a lot of money, but the government under Stark or anti-kickback takes a tainted claims theory of damages, which means that any claims that were submitted under an arrangement that violates either anti-kickback statute or Stark are tainted and therefore false, and therefore it's the entire value of the claims. So let's say you have Dr. Jones again, poor Dr. Jones, terribly uncompliant guy, and he is being paid in fishing trips by a lab company, and he orders a whole bunch of lab tests for people who need these lab tests, desperately need them, but he is being paid in fishing trips to send all these tests to lab company. And you know what? The government comes along, finds out about it. Dr. Jones' nursing assistant, who hates him, files a Qui Tam, and all of a sudden the government's investigating, and they say, oh, kickback, and they're right. Well, it's all the tests, even though all those patients needed it, because it's a tainted claim. And then the government's going to say, let's multiply that. And if you really want to settle this, let's double it. And because if you don't want to settle it, and we'll go to trial because it's a lay down case, and the trebling and the penalties, that $21,000 number there, are mandatory if the government wins a trial. So that's the hammer. And that's why so few of these cases actually go to active litigation, and so few of them, or most of them, settle. That's the False Claims Act in a nutshell. The other wrinkle is the Qui Tam provision of the Act. There used to be all these acts out there with Qui Tam provisions, right? It was a big thing back in the day when government was much smaller and private enforcement. This is the last one, and it traces its history back to the Civil War, where, half-dead mules and gunpowder that was sawdust were provided, so they enacted this thing, and it allows a private party to sue in the name of ex-rel, in the name of the government, and file this case. And it's a very, very powerful enforcement tool, because anybody can do it. And you can get these great insiders, right? I mean, some of these people have come forward with real inside information. I saw it in the government. I mean, they're right there. They're sitting there. They're like, yeah, that guy, Dr. Jones, said, I know that I'm doing it all wrong. And they come in and they say, hey, I was listening to Dr. Jones say that, and I know what he did. And it's great because the government all of a sudden has its case. So it's a very, very powerful enforcement tool. The problem is that anybody can do it. And because anybody can do it, they can just, file a case against you, and the government is statutorily obligated to investigate it, right? But it's out there. It's something you need to be aware of, and it's why you need to be particularly careful with internal complainants in this day and age. So we have here, and we're getting close. I want to leave a couple minutes for questions if anybody has any, but please feel free to speak up too. This is sort of the continuum of fraud, waste, and abuse, right? And when you kind of live in this world, you sort of automatically, without thinking, put stuff on this continuum. And you think, is it administrative? Is it an error? Did somebody just kind of mess up? Is it something more than an error? Is it an error that should have been caught? Is it an error that was caught and somebody didn't pay attention to it? So it's starting to get more onto the spectrum of fraud. Where does it fall? It's not. There's no hard and fast rules, but generally speaking, whenever you're dealing with these things, you're always trying to push it down to error, because error means repayment of the money, as opposed to double damages or OIG investigating you or the DOJ investigating you, anything like that. The last statute that's on here is something that I touched on just briefly, called the Civil Monetary Penalties Law. This is the OIG's enforcement statute. This is what they can enforce on their own. There has not been a lot of CMP enforcement in years past. I think that's going to change. The OIG has a new unit, the way they organize themselves in DC. They have a new unit that is charged with enforcing the CMP provisions as to generally smaller and individual providers. And what they're trying to do is they're trying to mop up people who are missed by these large False Claims Act settlements. So let's say you have a big False Claims Act settlement with a hospital. Dr. Jones was involved yet again, but Dr. Jones, he spends all his money on phishing. The government doesn't really want to go after, it sounds like a lot of money, but Dr. Jones is only worth $500,000. The DOJ doesn't want to bother with that because the large hospital company is going to pay $10 million. So they just kind of let Dr. Jones go by the wayside. Well, OIG is starting a program where they're going to try to catch the Dr. Joneses of the world. And after a False Claims Act settlement, they're going to come in and they're going to say, okay, we have the CMP statute, which allows us to do roughly the same thing. And Dr. Jones, we know you were involved, and you know what? We have the time to spend dealing with you, and we're going to spend it dealing with you, and you're going to have to settle with us. So, yet to see how that kind of turns out. Best laid plans and all that, but it is a new heightened era of individual enforcement. And you all may have heard of the Yates memo, which is something else that's floating around out there that says we're going to hold individuals liable. Well, the OIG is going to start trying to hold individuals liable, and they're going to use the CMP statute. This is just another listing of criminal health care fraud statutes, or criminal statutes that can be used in the healthcare fraud context and often are. There's no point in going through all of these. It's just to give you an idea that when these things do turn criminal, the range of conduct that can be looked at, right? It's very important to keep that in mind, because it's not just, criminal conviction requires more intent, really. You can't be knowing and reckless. You have to intend to do what you did. And it has to be proved beyond a reasonable doubt. So criminal statutes only come up in the most egregious cases. Dr. Jones seems like a real candidate. And, but he can be charged for not just not just healthcare fraud, but also, is he transmitting those bills over the wires? That's wire fraud. Is he signing somebody else's name to get it paid? That's ag identity theft. That comes with a 3-year mandatory minimum. So when you get into the criminal realm, prosecutors become very creative and start to think about how to charge you. And that's just an area you want to avoid, but it's just to give you a sense that there's a lot of potential things that could touch it. The last bit is about law enforcement actions, and then one final slide I'm just going to skip to because we're a little bit over, but self-disclosure. There's a way out of this a lot of times if you identify a problem, and that's self-disclosure. And self-disclosure can, you could spend another day talking about self-disclosure, but it takes many forms, and it goes from simply returning an overpayment to a MAC, all the way to walking into the U.S. Attorney's office and saying, we know this was going on and we want to report it, and we know we're going to have to pay some kind of multiplier, but we want to minimize the damage because we know how bad it was and we know how likely it is to be found. Each one is a case-specific decision. But I have seen instances where we have self-disclosed into an existing Qui Tam. So an employee has already filed. We didn't know anything about it. We show up at the U.S. Attorney's office and say, hey, we got a problem. And they say, hey, we actually know about that because somebody has actually filed a lawsuit against you. So good for you for recognizing that problem and coming to us before we sent you a subpoena. And it helped. The company paid a bunch of money, but they paid less. And they recognized that there was a problem, and they were able to resolve it and put it behind them. What? And no one went to jail. Yes, so that also a very good result. So that's the last little pitch there. I'm happy to answer any questions or take any comments. I want to be respectful of everybody's time though as well.
Real quick about self-disclosure. I was actually involved in a case or a client, not here, it was prior to being here, where we discovered there was an issue with a huge number of claims. And so we contacted our MAC, which was Cigna at the time, and we're like, okay, we found this, we know it, and they allowed, it was a long, drawn-out process, and it was not always pleasant, but I will say this, they allowed us to do a sampling and provide a spreadsheet to them, and we basically were able to settle without all the, because we did self-disclose, we were able to settle for a lot less than we had originally thought. So while it may be painful, it is definitely the right thing to do.
I think the key takeaway is that slide that JD had up there with the guy with his head in his sand. Don't bury your head in the sand.
Yes.
Something comes up, address it, deal with it, self-report it.
Be proactive.
Talk to your counsel, talk to JD or someone like JD. Use a third-party consultant to come in, and if there is an accusation that someone brings up, have someone verify that, kind of determine, do your own investigation. Is this truly going on? And if so, then take action.
Yes.
Do we have any questions at all?
Is there any state, this is all federal, but is there any state liability that attaches as well?
Yes.
Talk about state, but
And if you can repeat the question too.
Yeah, sure. I'm sorry. So the question was, is there any state liability that attaches to this as well? And the answer is absolutely. Almost every state has a state False Claims Act allegory. There are certain incentives and cost-sharing programs for those allegories to match the federal statute or exceed it. So most of them match the federal statute. There are also state law kickback provisions, and some states, I believe Florida, although don't quote me on that, have what are known as all-payer provisions as well. So kickbacks are illegal with regard to any payer. So Blue Cross Blue Shield or just somebody paying cash. You can't have kickbacks tainting those claims. So some states are broader, some states are narrower, but there's always there's always a state allegory out there. Enforcement activity is typically less, except in the larger states, although they do piggyback on federal False Claims Act actions. And so if there's a lot of times you see a Qui Tam against a nationwide provider, it'll be filed in all the states as well. And some states will pick it up and they get a steering committee together, and so you can have Medicaid dollars involved in those as well.
We've actually been dealing quite a bit with state attorney general office on various Medicaid issues, retained care issues.
Yeah, Tennessee is one of the more active states in terms of just pure state enforcement. Yes.
pray that we never get to this, but I'm assuming that my corporate counsel is probably not the best attorney representation because they help us with a lot of leases and business transactions. But does Kraft have business relationships with local counsel that specializes in this so that if we were to ever need that, we could work through?
Yeah. I'm separate of Kraft, and I specialize in it. And yeah, I mean, but I'm not going to plug myself. Be happy to talk to you if it ever happened. But I have seen. I think that's a very good point that you raised. That a lot of times business counsel is not equipped to handle this. And I will say that when I was in the government, I saw a lot of times where sort of smaller and medium providers would come in with their business counsel, and they would make very egregious mistakes. And I have since in private practice cleaned up a lot of those mistakes. So it's important. It's one of those things where, you know, I wouldn't claim to represent anybody in a med mal case, but there are med mal lawyers, right? There are lawyers that do this, and you typically want to find a lawyer that does this.
JD is a great lawyer.
Well, thank you.
Coincidence that your initials are also.
Yes, exactly. I was born for it. Yeah.
I was going to start out with that joke, and I'm sure JD's heard it a million times, so I thought I'm going to leave it.
Well, what states? I didn't realize that OIG was created in '76, which is when I was born. So I'm going to have to file that one away, too.
Any other questions? All right, well, thank you all for being here today. Thank you for our panel.
Thank you all.
Thank you.